Prayers.
Almighty God, who in thy wisdom and goodness has appointed the offices of rulers and parliament for the welfare of society and just government of men, we beseech thee to behold with thy abundant favor us, thy servants, whom thou hast been pleased to call to the performance of important trust in this land. Let thy blessing descend upon us here in this house assembled. Grant us that we may treat and consider all matters that shall come under our deliberation in so just and faithful a manner to promote thy honor and glory, to advance the peace, prosperity, and welfare of this country and of those whose interests thou hast committed to our church. Amen.
Correction and approval of records of votes and proceedings of the National Assembly sitting of Monday, 10th March 2025.
Honorable members, the record of votes and proceedings of the National Assembly sitting of Monday, 10th March 2025 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Honorable member for Nyamina West.
Thank you very much, Speaker. I rise to move that the record of votes and proceedings of the National Assembly sittings of Monday, 10th March 2025 be corrected and approved by the August Assembly. Thank you.
Seconder, Honorable member for Kiang Central.
Thank you very much, Honorable Speaker. I rise to second the motion.
It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Monday, 10th March 2025 be considered and approved. Honorable members, we all have copies of the said record of votes and proceedings, and as usual, we will look through it page by page, beginning with page 1, to be followed by your comments and observations. Page 1. Honorable members, we move to page 2. Hey, Gibi is going to the state. He wrote. When you read there. Honorable members, we now move to page 3. Nyanija.
The following honorable members were absent without permission. The last one, 58, Honorable Dauda Jeng, is on an official trip. And I think...
Honorable Jibimbalo.
Yes, I mean Honorable Dauda Jeng.
They are both of them.
Okay, I don't know for that one.
Honorable member for Nyanija. Any more observations? Pardon? Honorable member for Ilyasa.
Thank you, Honorable Speaker. The last paragraph, on page 3, at 20 minutes after 12 o'clock in the morning, the Honorable Speaker resolved the Assembly into a committee of the whole House. I think it should be in the afternoon, not morning.
Yes, thank you, Honorable Member for Ilyasa. Any more comments on page 3? Honorable Member for Nyanija.
Let me just talk. I just saw something here. I was trying to make some reference, but let me just put it forward. Majidi. Okay. Number 1, where it's the correction and approval of the the record of votes and proceeding of the National Assembly sitting. Okay. Where the motion reads, Honorable Aliu Balde, member for Jara West, moved the motion and was seconded by Honorable Issa Conte, member for Jimara, for the Assembly to consider and... No, it's okay, thank you.
Honorable members, we now move to page 4.
Yeah, it's just a small one. At number 3, Gregson put an agreed to. The to is missing before it that.
Thank you, Honorable Member for Nyanija. Honorable members, we now move to page 5. Honorable members, it has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Monday, 10th March 2025 be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk, may we proceed?
Bill, Order 72, consideration stage. Continuation of the consideration stage on the Criminal Procedure Bill 2020 by the Honorable Attorney General and Minister for Justice.
Honorable members, you will recall that after the second reading stage, the bill automatically stood referred to the ABC committee. Thereafter, the ABC scheduled the bill for consideration stage during the previous ordinary sessions in December, precisely on Tuesday, the 10th of December. However, the Assembly could not complete the consideration stage of the Criminal Procedures Bill and stopped at clause 181 of the bill during the said sitting, and hence suspended the process to a later date. Therefore, the bill is appointed today for continuation on consideration stage in accordance with Order 72. During the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now, therefore, resolve the Assembly into the Committee of the Whole Assembly to give consideration to the bill entitled Criminal Procedure Bill 2020. The Assembly is now resolved into the Committee of the Whole Assembly. Honorable members, the Assembly will now go into the Committee of the Whole Assembly to consider the Criminal Procedure Bill 2020, clause by clause. We will be guided by Order 72 of the Standing Orders during the consideration stage. Honorable members, we will 182,
182 special verdict.
Committee, there's an issue.
Why is that?
Let me even open their report.
182. In the heading. Yes. To include omission as per current CPC. Yes, we have.
Yes, go ahead.
We'll raise it because we have. Yes, Chair, the committee is observing in this heading, the committee recommends to include omission as per current CPC. Omission. Yes, it looks like it's, I cannot definitely remember, but maybe the minister will help. What? Because that recommendation must have come from them, from the. This is dealing with. Sorry.
All right. Can you read the whole thing? That will guide us. Yes.
Special verdict. 1. Where A person is charged with an offense, and B, the offense at the trial shows that the person, being of unsound mind, is not responsible, according to law, for his or her action. That person's action.
That's where it is action or omission.
Yes, I think that's where it's that person's action or omission. The omission is missing. We are recommending that we put omission there. That person's action, for example, if you go by our distinct or omission, the court shall return a special verdict to the effect that the accused is not guilty of the offense by reason of unsound mind when the offense was done. If it appears to the court that that person did the act charged but was of unsound mind at the time when the act was committed. 2. Where the special verdict is found, the court shall A. forward the court record or a certified copy of the court record to the minister responsible for health, and B. order the accused to be kept in custody at a suitable place and in a manner directed by the court till the president's pleasure is known. Yeah. The minister may A. signify the president's pleasure by warrant signed personally by him or her, and B. from time to time give an order for the safe custody of the accused as a person of unsound mind during pleasure in a place of detention or any other suitable place of custody, and in a manner that he or she considers fit. at the top, where you say, yes, where you say in B, where a person is charged with an offense, and B, the evidence at the trial shows that the person being of unsound mind is not responsible according to law for his or her action or omission. We want to add omission there. That person's action or omission. So,
the first one is for his or her action or omission.
Yes, we want to add omission.
Yeah, her action or his or her action or omission.
Yes.
And then comma, and then that person's action or omission. Again, am I right?
That's the suggestion from the committee.
How do you connect that to the next sentence? No, even as it is it connected? That person's action
or omission, the court shall return, etc. Then it goes.
How do you connect those two? You have said in the first one, according to law, for his or her action or inaction. Then if you comma, then you have that person's action or inaction, the court. I don't think that rhymes well. If it stops at the first one, for his or her action or reaction, then the court shall distinguish. But if you say that person's action or inaction,
we are saying you have the person's action is mentioned.
You add action.
Inaction. What he is to do and he has not done.
I understand. No, I am with you on that. You know, the addition of inaction on the first bit, his or her action or inaction, comma, you know, the next one, that person's action, whatever, or inaction, does not rhyme with this one. Does it rhyme? Does it work? But what now? You have said this. Now, what about that person's action or inaction? What do?
Yes, the court shall
no, but you have said here, according to law, for his or her action or inaction, that the for me, that person should be removed. If it is connect directly to the other one, or there is something omitted that they wanted to state,
yes,
which is not there. Yes, yes.
Chair. That person's action.
You know you have action here.
Yeah.
Huh? Person, yeah. His or her action or omission. That person is going to delete again. You understand? Because you have action here. His or her.
Yes. Yes.
Proposal. Where you have your this for his or her action or inaction and that person's action or inaction, we remove all that. His or her conduct, full stop. Sorry, comma, then it continues. It means it's not responsible according to law for his or her conduct. The court shall return a special continuum. Yes? Who wants to talk? Huh? Sabak Sanjal?
Yes, Chair. I just wanted the committee to guide us and tell us if there is a problem there, because I have not seen any problem with this as it is. And that word omission they want to add. is changing the whole thing because omission is an act.
Honorable, we have a new proposal on the table. We are removing all those things. We want to add just put conduct. Action, inaction, whatever. We just want to put conduct. That's the proposal without debating. Yes, honorable member for.
Yes, I think.
Yes,
I think the proposal you have now about conduct, I think is appropriate because the conduct, I said the conduct you have now, I think is appropriate because it talks about act or omission in general. So I think what you have right now, I think it's good to go. Thank you.
Honorable Speaker, the reason why we deem it necessary to put this omission here, we are making reference to the Criminal Procedure Code. That's why the committee resolved that the committee recommends to include omission as per current CPC, because we believe you can only punish the conduct through act or omission. An act is the one that is here. So we include this omission there so that, it will be in tandem with the Criminal Procedure Code provision. Yeah.
That's the answer.
Yes.
As part
Thank you. Yeah, I think he's right. So on that note, let's state it as according to law for his or her action. Already we have action or omission. So that person should be removed. We go ahead.
Okay, Honorable Opasalu.
Yes, even when you reference the criminal code, it also deals with, like you said, act and or omission. But the conduct itself actually covers both. Because your conduct is to act or your conduct not to act. So the conduct itself actually covers both.
We want it to be explicit that you are responsible for your action and your refusal to do action. So those two, we want it to be explicit.
Yeah, the proposal that is being floated came from the legal people. I don't know, but you have to make the final decisions. So what do we do? Because for me, my problem actually is, I think you have an idea. It's good, but the other part of it, where you have that person's action or inaction added to it, that is incomplete. Then there's something should follow that. Otherwise, it's not relevant. Yes, no, just to remove it. It's just to remove that one. You just to remove it and it continues with the court shall continue. Yes. Because you are just repeating what you have just said. That person.
Honorable Speaker.
Yes, please. Honorable AG.
I think this clause would be good when we say where the evidence at the trial shows that the person, being of unsound mind, is not responsible according to law for his or her action or omission.
Simple.
For his or her action or omission.
Yes.
That's where it stops. Yeah. This is what we are exactly.
Yeah. Exactly.
Are you in line with that?
Yes.
His or her action or omission.
Action remains. Action or omission. So the action remains, yes.
Honorable members, it is proposed that clause 1A2, special verdict, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
183. The regulation of places of confinement for persons of unsound mind.
No, nothing on 82.
No, for 87, according to the committee report.
It is proposed, yes, on 183, yes.
We believe this is talking about something with unsound mind, and I think it's only health experts that can be able to determine this. So I'm proposing where you have the minister responsible for health shall make regulation prescribing ABC, etc. Because here you're talking about somebody who has unsound mind.
Prescribing?
May. It says may.
Pardon?
May. I said we change may to shall.
No, but what about if it is not necessary?
No, no, here we're talking about.
I think the may here implies that when there is necessity, it will be done. Yes. No. It is proposed that clause 183, the regulation of places of confinement for persons of unsound mind, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 184, escape and retaking of persons of unsound mind.
It is proposed that clause 184, escape and taking of persons of unsound mind, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 185, periodical reports concerning persons of unsound mind.
It is proposed that clause 185, periodical reports concerning persons of unsound mind, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 186, procedure when accused does not understand proceedings.
It is proposed that clause 186, procedure when accused does not understand proceedings, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 19, judgment. 187, mode of delivery judgment, delivering judgment.
It is there is something. 187, you have something. I thought I will complicate it. In fact, it's faint.
Yes, Chair, 187. The committee recommends that of the minutes that be deleted.
Huh?
187. Sorry.
You are at 178.
We are here. 187
3A and 5.
is the mode of delivering judgment, isn't it? 187 3A, the committee recommends that point or points be changed to issue or issues. You've seen it there, 187.
All right. Just here, the judge or magistrate shall record his or her judgment in writing, and the judgment shall A, contain the issue or issues you want. Yes. Huh? For determination.
Yes. Before you change it.
Instead of point or points.
Yes.
Yes, go ahead.
Yeah, he needs to tell us why are you saying issues, not points? Because in court, who are they to say? We want to know the legal term used in the court. Is it the points or issues? No, I want to be clear.
You determine issues.
That this is more apt in this circumstance than the word point. Now, you agree or disagree? If you are not convinced, yes, you can come up with your case. No, you are not racing. You are going to say something.
Something.
What are you saying?
I'm saying I'm not convinced to change from point to issues. Can they buttress on it?
No, you should buttress. You should be convinced.
Why
you should say why you are not convinced.
Why should I buttress when it's not from me, it's from them?
No! These people looked at it. They brought you something that is their judgment. You don't want that judgment. You think it's not appropriate.
No, I want
you bring your reason.
No,
otherwise, if you cannot bring your reason, then it means they are right.
No, Chair. I want it to be backed by facts.
Yes.
I want it to be backed by facts.
More of delivering judgment now.
Pardon?
187. More of delivering judgment. Their caption is on sub 3, clause A. Contain points or points for determination. Now, what is the mode in which they deliver judgment? Do they use points or they use issues when they're delivering judgments? No, I mean, do they deliver judgment based on points?
Yes,
based
I'm coming.
Yes.
We are with the belief that in most cases, issues are the ones that are determined at the court. You determine,
delivering judgment now. It says that the judge or magistrate shall record his or her judgment in writing, and the judgment shall contain. These are judgment now, not issues now. What points? Points or points of for determination. What you are saying, you are missing the point.
Honorable, I think here. Honorable, I think they are brought in their proposal. Most of us are laymen in terms of law. So that's why we have our technical backwards. Let's not waste time. Let's hear them advise us.
But Chair. No, what they're saying is that the issues are what have been discussed in court.
The questions you are asking, they know that better than all of us.
Okay, yes.
So let them advise us.
Attorney General.
Chair.
It's issues.
Huh?
Chair.
What issues? You refer to.
No, Chair.
Please. We are asking them. I'm getting an information here. He's telling me they refer to them as issues, not points. Yes, Honorable.
Yes, I think I will align myself with the committee, because what happened is you formulate issues for determination. So that's what they normally do. They can formulate 1, 2, 3, or 4 points for determinations. So you cannot call them those points, but they formulate issues that they need to determine each one of them. So I think the committee is in line. Yes.
Yes, but you see, in fact, I don't think we need to bog ourselves with this. We are mostly laymen, yet we are lawmakers. This is why we have the legal luminaries with us. The process, if we want to know, we don't know, we ask them. What they tell us is how they do it. To who?
Committee. A committee chair raised something. We want clarification. If they cannot, refer it to the Justice Department. But you said no, you should come. How can I come? When a point is raised, I don't understand. I expect.
No, that.
Yes, if the care cannot convince. If the care cannot convince.
No. Your own is.
This is what I'm saying.
No, your own is different. You cannot make it look like others. Your own is different. Your own is different. So, honorable members, we change it to issues, isn't it? Somebody is talking here. Somebody is talking. Who is talking on his own?
I am just saying that we have the legal expert, but as much as they will guide us, we also have to agree on the terms. When we don't agree, then we waste issues. You said we have the legal expert here.
Yes.
And the legal experts, based on what they say, that's what we go by. I said, no, we don't go by that. We have to agree onto those things. If we don't agree, then we rule it out.
Honorable,
yes.
You see, Honorable, that decision is only yours. None of us will go by that. On the issues that we can define, yes. But these are legal issues that you don't know. You want to make a judgment on that for the Gambian people?
No, we are
and
not
leave behind those. This is why they are here. So when you don't know, they will inform you what is right, so that you do the right thing. It's not for you to say you are the legislature, you can do it anyway and anyhow. That's not why you are here. It has to be informed. When they make the suggestions, we heard it. So that is just on the sidelines. Can we proceed, please? Is there any more on?
Chair, in 187.5, the last word of that paragraph, there is the word defendant. We want that to be changed to accused.
Why do you want
Instead of defendant, just the accused.
Who is accused?
The accused person. Okay. No. Yeah.
Huh?
Yes, accused person. We want to.
You want
defendant.
In the presence of the accused. Of the accused person instead of the defendant. You know, for ordinary people like us, it means almost the same. But what is the legal? What is the implication legally? So that we put there. Okay. Yeah, ordinarily. But for them, it's different. The accused is what they use most. So this is what we are dealing. We are dealing with their domain.
That's why most of these things.
Yes. So instead of presence of the defendant, in the presence of the accused person. Am I right? Hey. Accused or accused person? Any more? Honorable members, it is proposed that clause 187.
Put this to the AG first, the defendant.
AG, we don't need to put some of these things to you. As we go, you come in and then help us. Yes. Yes, exactly. But what about this accused and then this defendant? Okay.
So we are changing it.
Yeah, we've changed it to accused person. It is proposed that clause 187, mode of delivering judgment, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 188, contents of judgment.
Saying 188, 2A, 188, 2A. The committee recommends that she, where it say where he has, we're saying he, she.
Where he or she.
Yes, he, she should.
Don't say he, she.
Yes, I know, that's what I'm saying.
Yeah.
Where he or she. Instead of just he. That's what we want to add there.
No, it's not there.
A.
The beginning.
C is missing, C.
Yes. Yes.
2A.
Yes, exactly. You are right, very right.
And 4.
Yes, and 4, we are saying the committee in 4. The committee recommends that there is an off missing where the provisions of this section, you've seen it? Yes, that off should be there, which is missing. Those are the 2 corrections. Thank you.
Yes, Nyanija.
That he or she issue, I think if I could recall, some of the bills that we passed here, when these issues were raised, the drafters will tell you in drafting we only use maybe he or just the masculine form, if I could recall. So I don't know why this he or she. If you want to do that, every bill will put he or she, he or she, he or she. Yes, I could recall this.
It's true, but it's not. You know what they are telling me, Nyanija, is that yes, that has been the adage before, but contemporary time, things moving, it does not seem to hold now. This is what they are saying. They have left you behind. They have gone.
Honorable Chair,
Yes.
I am far ahead of them. I am far ahead of them. The issues will come, honestly.
What I meant by they left you behind is they are no longer with you.
No, I mean, in the general lens they are seen, I'm even using a microscope to see better than them. So, but I am raising this thing if in case other issues come. I'm honest. I'm honest.
For me, the old one is better. The he means he, she. But now, yes, that's what it means. Yeah, no, you gave it that meaning. You negated it. But it was accepted as he, she. Everybody accepted it. It is when you came out with your these clumsy little things that yes, it's little. This is language. He in language we said you did the definition. You defined it to say he means he or and she. That is defined. So what does it mean? If you can even say she and you say it means he or she, it still is good. But you'll be writing he or she, he or she, he or she all the time. No, now it's now that we say it. No, her, I say her. Yes?
Speaker, but as the world moving, we want to move with the world. You cannot go to 16th century or 14th century. So the language that is accepted universally now, accept that. It's not that we negate it. Nobody negate it.
I don't know. You don't listen, you comment. I am not denying it, and nor am I not accepting it. No, so no, don't say that. I said the idea that it was brought in by this the group, the so-called human rights activists or whatever. Yes, you are the people who brought this, gave us more problems. But before that, it's not about acceptance. We have all accepted it. You listen before you comment. Ma fomba bula nyama. But you have to make count. More for it. More for it. No, you tell central body. Let him be listening before he responds. Yes, listen before you respond. Think before you speak. You don't speak and then think. It's wrong. Let's continue. Have I put the question? It was this man. 188. It is proposed that clause 188, contents of judgment, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 20, costs and compensation. Clause 189, costs.
It is proposed that clause 189, costs, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 190, compensation in case of false and vexatious charge.
Have you read it? The committee, I agree. Now it's my members. Huh? We know you don't have issues. That one is clear. Members, you also don't have issues. Yes?
compensation shall not be paid before the expiration of 1 month from the date of the order.
Now, what you do is read 6 and then B.
See, when an order for payment of compensation to an accused person is made in a case which is A, subject to appeal under subsection 4, which, no, yes, A, subject to appeal under subsection 4, the compensation shall not be paid to him or her before the period allowed for the presentation of the appeal has elapsed, or if an appeal is presented before the appeal has been decided, and B, not so subject to appeal, the compensation shall not be paid before the expiration of 1 month from the date of the order. So I'm looking at 1 month. Hope is not a short period.
Yes.
Yeah, because the appeal case may take more than 1 month.
No. This one does not read that. This one says, in a case which is not so subject to appeal. This is what you are reading this time. That's why they gave 1 month as his period. Yes. If it is subject to appeal, you saw it here, that it will not be paid until the appeal is gone through.
Yes, Chair. Yes, I think the time period is short. For example, if it is the government that is supposed to pay, because again, you with government you deal with budgets and you deal with cash allocation. So if you make it that short, 30 days, and
no, it doesn't mean you are to pay it within that 30 days. I think this one is usually a month notice when a judgment is given. The person has at least a month to put in an appeal or what. I think that's the last period they are looking at, whether the person will make those things. It's not about the payment out, the time for payment.
Just giving you a period of time. You know when a judgment is made, there are grounds for appeal. But in some certain cases, the appeal time period may have passed. So if you have to be compensated, for example, by the government, and there's a duration of appeal, that duration would serve at the time. But where an appeal is not, that's B, that's what Sulema was saying. When an appeal is not, then you have 30 days. That's too short. This is about compensation.
No. They do read it properly. It says compensation shall not be paid before the expiration. So you cannot pay it before 1 month expires. Then after 1 month, it's open. Yeah.
You want the compensation to take 2 months, 3 months, 4 months. 1 month, it's okay for government to do it. If they think they cannot do it, let them go back to the court and let them look for an extension.
It doesn't say it has to be 1 month exactly. It says
yes.
Yes, and we don't want them to also use this thing as a...
Honorable member, in fact, it says before the expiry of 1 month.
Yes.
It's not limited to 1 month. It cannot be paid before the expiry of 1 month.
It's fine.
Yes. I think we are fine. Member for Central Body, you are fine, isn't it? It is proposed that clause 180, compensation in case of false and... It is proposed that clause 190, compensation in case of false and vexatious charge, stand part of the bill. Those in favor, please say no. Please say aye. Those not in favor, please say no. The ayes have it.
Clause 191, compensation for material loss or personal injury.
for 196.
Huh? It is nothing on 191. 191. It is proposed that clause 191, compensation for material loss or personal injury, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 192, cost and compensation to be specified in order, how recoverable.
It is no issue. Members, no issue. It is proposed that clause 192, cost and compensation to be specified in order, how recoverable, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 193, promotion of reconciliation.
Honorable members, no issue. It is proposed that clause 193, promotion of reconciliation, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 21, restitution of property. Clause 194, property found on accused person.
No issue. Honorable members, no issue. Huh? Right.
Obasalon. Now, with this property, when it's found in the possession of the accused, and let's say that the property actually has deteriorated from when it was taken from the person, what actually happens? For example, if it was a vehicle or any like a movable property, for example, and it's found at the hands of the accused, but the value of the car, or for example, the time it was taken to now, there's deterioration, what happens? Do you just take it and give them, or there will be compensation? Yeah, something like, yeah.
Obasalon, you know, we just left part 20, cost and compensation. That's from clause 189 to 193. I think that it should be taken care of in those places. Pardon? I can't specifically tell you where, probably. I said I hope it should be there. It is important that we all read this document before we agree. Honestly, we're dealing with something between life and death, my brothers. An error here.
Honorable member for Opasal. Of course, I know you understand this particular clause. This is restitution. And restitution involves two. But it also, the subject is the material found during investigations. you restore it to the owner. Sometimes the owner can be the accused person himself. Sometimes the owner may be a recovered material belonging to the person who complained of if it is theft, the person's whose material were stolen. So it will be restored either way. If it belongs to the accused person and the accused person is convicted, if it is something of value, it may even be used to recover fines or compensation or cost. All right, so let's say it can be forfeited and placed. That's what B is saying. It can be applied to payment of any fine or any cost or compensation. If something of value was found on the accused during investigation, he is prosecuted and convicted. Instead of returning his property to him, if the property can be liquidated to take care of his fines and cost or a compensation, it will be done. But if it was material that is recovered and belongs to a third party, it will be restored to the third party. Now, what you are asking is if the material recovered belongs to a third party and may have depreciated in value, that's where compensation comes in, because that's a material loss. So compensation will be ordered to take care of that.
Yes, go ahead.
Okay, so it's well understood. But there's no need to include any clause in there where there is deterioration or there's no need for now.
No, because there is already a provision for that. Yeah.
It is proposed that clause 194, property found on accused persons, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 195, restriction on the disposal of property of the accused person.
Any? Nothing? Members? It is proposed that clause 195, restriction on the disposal of property of accused persons, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 196, restitution of stolen property to owner.
Yes, we have just little issue there. Chair, 196.11. If you look at 11, the second line, well, let me read. Wherever any property is or may be the subject of an order under section 194 or this section, that or should be off of this section. You've seen it? Yes. That's
of this section.
This section is 196.
This section is 196. There is no 194. You know, if you say 194 of this, for instance, this what would you call it? Of this part or whatever, but it cannot be this section. No. Of this section.
The or is correct. It's either or. It's not off. The or is the correct.
Whenever any property is or may be subject of the subject of an order under section 194 or this section. Yes, it may be an order under 194 or this one. Huh? You've seen it? Yeah. It's okay. Any more on 196? It is proposed that clause 196, restitution of stolen property to owners, stand part of the bill. Those in favor, please say aye. Those not in favor, please say aye. The ayes have it.
Say that twice. Say no.
On the whole, you are all listening. I put it again. It is proposed that clause 196, restitution of stolen property to owner, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 197, recovery of property from convicted person.
Honorable members, no issue. It is proposed that clause 197, recovery of property from convicted persons, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 22, miscellaneous provisions. Clause 198, the person accused of any offense may be convicted of attempt.
It is proposed that clause 198, the person accused of any offense may be convicted of attempt, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 199, person charged with an offense may be convicted of being an accessory after the fact.
On committee? Members? No issue. It is proposed that clause 199, person charged with an offense may be convicted of being an accessory after the fact, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 200, when offense proved is included in offense charged.
It is proposed that clause 200, when offense proved is included in offense charge, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 201, person charged with burglary, etc., may be convicted of kindred offense.
Yes. Chairperson, can we be enlightened here? Can we be enlightened? Because yesterday we agree on a procedure. But I know that person charged with burglary, etc., our legal luminary here, Ya Sanya, was saying that you cannot put etc. But this is okay because person charged with burglary, etc. Yeah.
So this one, kindred, you said means similar offenses.
Yes.
You know, you people, for one thing, one crime, you will charge 10. Yes, honorable member for Janjambure.
Yes, Chair, I just want to align myself with what the majority's leader has just proposed, that we remove this etc. in our laws and have something specific. No, it's not okay then.
We have 10 pages of names to be listed. issue of burglary. It cannot be outside that. Yes. You don't need to be convinced, you just need to know. Convinced is another thing, when you have the facts on the table. But this one, this is the fact. You only need to learn it and know it, that these are the facts. It's not, you don't argue on facts. When something is right, you only accept. There is no more questions. It is proposed that clause 201, person charged with burglary, etc., may be convicted of kindred offense. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Raise your tax, we see. Okay, 2. In favor, raise your tax. No, we want the figures. Raise your tax. We want to count, they are counting. If you don't vote, you can abstain if you want to.
They are raising the wrong tax.
We are 23 altogether.
Honorable, please, people are mature. Let people vote by their consent. Please.
He didn't vote yes or no.
Pardon? No, but then if you don't do that, then you have abstained. It's either or. Yes, you have to indicate that you have abstained. No, you got to do one. Abstaining, yes, put it down.
I've got 3 already.
The yes is 14, the noes are 4, and abstention is 3. Yeah. Abstention 3. Huh? Who?
No, it's not 12. It's not 12. It's not 12.
The ayes have it. Go to the next one.
He's calling your attention.
Who? Janyambura, do you want to say something? Okay.
We're 23 in chambers.
Now, the problem here is, we will not reconcile that. Because some people will not vote, they will not abstain, and they will not show up. So, what can you do? Yeah, this is what we are saying. It's what we have seen and we can act on. Go ahead.
Clause 202, conviction of false pretenses on charge of stealing and vice versa.
It is proposed that clause 202, conviction of false pretenses on charge of stealing and vice versa, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 203, conviction on infanticide of infanticide on charge of murder.
Infanticide. Have you read it, honorable MPs? You have satisfied yourself and your conscience. Huh? Pardon? Those talking about the back, are you talking about the issue? He's reading. No, but it is proposed that clause 203, conviction of infanticide on charge of murder, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 204, conviction of incest lawful on charge of rape.
Conviction of incest lawful on charge of rape. Sorry? It's correct. It is proposed that clause 204, conviction of incest lawful on charge of rape, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 205, persons charged with misdemeanor not to be acquitted if felony proved, unless court directs so.
Members, no issue? It is proposed that clause 205, persons charged with misdemeanor not to be acquitted if felony proved unless court so directs. Not to be acquitted. Who can acquit without the court?
What is it? It's basically saying that you are charged with a
misdemeanor.
A misdemeanor, a lesser offense, right?
Yes.
But then the prosecution.
A person charged with misdemeanor, a lesser crime, not to be acquitted if felony is proved. Something bigger is proved. But you charge him with the lesser crime. If you go to prove a bigger one, that's not what you charge him for. Can you explain?
It's protective.
Can you explain?
layman understanding is that Natare Yemu accused on misdemeanor now, but fact now reveal Kafuku Aimenke is more than that. It's not a felony. It means that Ita punished twice. Iba punished on the felony, but Ita punished on misdemeanor again. No, follow. Okay.
Honorable Speaker, let me.
Chair, decorum.
Let me simplify this. My take of this is, if you are accused of a misdemeanor, which is a lesser offense,
yes,
and the trial concludes, and the court evaluates the evidence and reaches a considered decision that the misdemeanor that you were charged is not proven, but evidence revealed that you have committed a felony. Now, the normal situation is you will be acquitted and discharged because what you have been charged has not been proven. Now, this is a bit of a novelty. This is saying, because there are implications for acquittal. When you are acquitted, you cannot be charged again for that any other offense based on those facts. Because once you are acquitted after a trial, the facts that were used for that trial are disposed of. So you cannot be charged again relying on the same facts again, even for different offense. You had it's like the prosecution they've got their go, they either make it or miss it. But this is saying now, if the court now reaches that conclusion that a bigger offense may have been committed, instead of acquitting, the court now need to make a decision and make a pronouncement. Either one, to allow you to be prosecuted for the felony that he is now seeing clearly before him.
Exactly.
And in that case, if he is going to allow that, then he is only going to discharge you. He will not acquit you. He can make that order.
Yes.
But he will not convict you there and then because you were not charged for felony.
Exactly.
He would, instead of acquitting you, he will discharge you to avoid this principle of double jeopardy. Then he is now leaving it open now for the state to come back and charge you properly with a felony and prosecute you. No.
Judge will discharge you, and they go back for you.
That's
No.
Yeah, this is what I'm saying. They have been doing it. The same thing here.
Let me differentiate.
They have been doing it.
Let me differentiate, Honorable Speaker, what is happening now.
This is what I'm saying here. He said, okay, let's listen to
Let me differentiate for you. What is happening now? Usually, if the state can withdraw the case at any stage before judgment, and usually that's a discharge, unless the court forms the opinion that sufficient evidence has been led and a retrial may prejudice the accused, the court can use its discretion to pronounce an acquittal instead of a discharge. But ideally, when the state is entering a nulli prosecute, it's supposed to be a discharge. Exactly.
We were discharged by the no, it doesn't matter, and then when we were discharged, we went home, and then they came back for us. The police came back for us. They took us there to be charged again, but the case never came up because they had nothing. It was political. It was myself, my wife, my brother, the wife, and my cousin. It's political. I will tell you, the reason was why we left here to go and register in Alberta. I hail from Alberta. Why I left here to go and register there. When the Honorable Minister himself hails from Sika, he goes to Sika with his family to register. It was no crime. But for me to go with my family to register in Alberta was a crime. They took us to court, we were acquitted, they charged us, acquitted, we come, just that. So this is what I'm saying, it happens. This is a personal experience. Yes, because when it happened, it was one magistrate, it's in book. This was 1980. Yeah? It was 86 or 87. You know, that's why when people glamour about human rights and democracy, sometimes it gets very interesting. All right, so Honorable, we are comfortable, isn't it? Which one is it? 204? 205. It is proposed that clause 205, person charged with misdemeanor, not to be acquitted if felony proved unless court so directs, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 206, conviction on other charges pending.
It is proposed that clause 206, conviction on other charges pending, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Take into consideration any other charge of the same kind then pending against the accused person. If the accused person admits the other charge and desires to be taken into consideration, and prosecutor of the other charge consents. Okay. It is proposed that clause 207.
No, I've not put it. You put this one already.
Yes, yeah, okay.
Clause 207, right of accused to be defended.
It is proposed that clause 207, right of accused to be defended, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Part 5, procedure in trials before subordinate courts. Subpart 1, provisions relating to the hearing and determination of cases. Clause 208, non-appearance of prosecutor at hearing.
Non-appearance of prosecutor.
Yeah.
Sometimes you will be taking people to court, they will not come. And the person is reminded they are wasting time. Have you read it to say there is no problem? If they cannot come to court, let them release the person.
That's what the provision is saying.
That's what the provision is saying.
Yes,
yeah, okay.
But Chair, I just needed a little bit. I just needed a little bit of clarity on that from probably the AG. Understanding that district tribunals falls under subordinate courts, and they adjudicate criminal offenses relating to customary laws, and most of the time they do not require prosecutors to be present. Do they fall within this category? I want that to be enlightened.
The criminal law, you have to have a prosecutor. If it happens at your chief's court, you are not satisfied, just go to the magistrate court. Yeah, is that what he's saying here?
Yes.
So I read.
No, it's there already, don't read.
Chair, he's saying
if in a trial,
if in a trial before a subordinate court, A, the accused person comes before the court on a summons, warrant or otherwise, and B, prosecutor, having had notice of the time and place appointed for the hearing of the charge, does not appear himself or herself or by his or her counsel, the court shall discharge the accused person unless for some reason it thinks it proper to adjourn the hearing of the case until some other date upon such terms as it thinks fit. So that's what it is saying. Yes.
That's where my headache is. You know, when it stops at that place, the court shall discharge accused person, full stop. But when it came unless, you are back at square one. That's what is in the current law. But we are now moving into the 20. There are no innovations. The same things will apply.
May I ask that, knowing what I know, leaving this at, let's say, on one shot, maybe a bit of a challenge. I don't know whether we could give a second chance. For example, if this happens on 2 consecutive times, instead of just once, because the prosecutor may not be absent, may be late. The case may be set for 1 o'clock. He may be late for 30 minutes and the case is called. And the court looks around, the prosecutor is not around, he discharges the person. This could all make law enforcement very difficult. Remember, this is public interest. This prosecutor is acting for the state. And these people could sometimes be very dangerous criminals, and if we allow them just to be released because they appeared once and the prosecutor is absent, and the court will have to release them just like that, just once. I think we can do it 1 or twice, sometimes maybe 3 times. Because it becomes habitual, then I see. Because also it could be expensive. If the person is released and it's such that the state cannot allow the person to be released, then we have to incur more resources to go and search and arrest and bring back. And still cost to the state. So we have to look at why the whole purpose of the whole thing. Yes, we want to respect the individual right here, the right of the person to speedy trial. But we also have to look at the rippling effect of it on society.
I think for me, I'm satisfied with that. I think this committee is there. This unless has created that room. Your fear, I want to believe, can be addressed around that. There is a reason for the adjournment. That's a genuine reason for adjournment. Whether we make it 1, if such reason exists, you can rely on that and request for adjournment.
Mr. Speaker, speaking from experience, if the prosecutor knows he's not going to make it to court, he will communicate. But we are looking at a situation where he is late. The court has no idea why he is not here because he's not able to communicate. He is on his way coming, he is late. And we have to just release, discharge the suspect. Because for the court to have reasonable basis to adjourn, the court normally would have been informed the reason for the absence. By the way we proceed, if the court has not been contacted, the court doesn't know why the prosecutor is not here. The court will lack the reasonable basis for adjournment. So he will deem that it is absent and we have not been notified why you are absent, therefore we will release the suspect.
But there's a counsel there, the counsel also is there.
MPI is, Honorable Minister, it's not good to leave a criminal to go home. But equally, it's not good an innocent person, you are detaining him somewhere and he has not got his freedom because somebody is not coming to court.
Not all accused persons are detained. And
no, this
a good number of accused persons we are trying are on bail.
No, agreed. But they are agreed persons who are under detention and for long.
Here we are not even distinguishing between those that are under detention and those that are under bail.
Agreed.
We are only giving a free right to the court that when the accused appears once, the prosecutor is not there, release.
No, I agree with you. Yeah. What I'm saying is it covers both those on bail and those who are under custody. Yeah, but taking those people under custody, why knowing that there is a law like that, why don't you allow somebody to be there before you? If you cannot be there, ask somebody to be there.
Yeah, can you hear me? Chair, also, if you look at the next provision, it said that the prosecutor haven't had notice of the time and place appointed for the hearing.
Pardon?
The prosecutor B, having had notice of the time and place appointed for the hearing of the charge, does not appear himself or herself or by his or her counsel. If he's not there, probably the counsel will be in picture.
Yes.
So at least there is safeguard now that the counsel also can step in.
No, you're missing the point.
He's saying, how? What he's saying is, what he's saying is, if the prosecutor, probably he's taking it as the chief DPP or whatever, but the prosecutor, if you cannot go, you send your counsel or somebody else.
He's saying that person that you have sent is the one who cannot communicate.
He cannot communicate.
I believe he's trying to.
No.
No. I'm just saying that if you look at the second paragraph, it said the prosecutor haven't had notice of time and place appointed for the hearing of the charge. Yes?
That's fine.
This is what I want him to know. He thought you were.
No, I'm telling that it's safeguard now.
Uh-huh.
And again,
Okay.
on the ages, the notification for for being absent can always be given by the judge or magistrate. Yes, similarly, even whereas it's supposed to be late, you can also give notification that you'll be running late, just like National Assembly. We know that we'll be coming, but we'll be running late. And the judge or magistrate can also give the same notification. Yes, I'll be coming, but I'll be running late. Just like giving notification that you'll be absent. I think it's applicable on both sides.
Yes. What I'm trying to say here is, I see the rationale. We're looking at the rights of the accused here. Yes, we have given the court the discretion to adjourn or to discharge, but we have not restrained the court. The court can discharge even if this thing happened once. I am saying let's restrain the court a little bit to say you can do it if it is the second consecutive time it is happening, not the first instance. Because for me, prosecutor being absent only once is in as much as we want to respect the individual right, for that to ground a discharge of an accused person. Yeah, but we are not restricting the court. The room for adjournment is, listen to the language. It says, if in a trial before subordinate court, the accused person comes before the court on a summons, warrant, or otherwise, and the prosecutor, having had notice of the time and the place appointed for the hearing of the charge, does not appear.
Honorable, but I think this is not a new clause.
Even if it is not new.
It has been in practice.
Yes, but I know the challenge.
Yeah, because what I was going to ask is, are there any known examples where the judge sent somebody on the first absence? There is nothing on record. These judges will never do that.
From your experience,
Magistrate or judges, anybody? Is there any experience, any on record?
Usually they will say 3 times.
No, this is what I'm saying. Not the first one they will do. Whether you put it or not, it will not be first one.
So what's the purpose from now?
Because in practice, it has been on. Is presumed innocent until proven guilty. So if you go for some delayances of some people, he continues to be in custody or to be going and coming because the person who brought him there is not coming on time, he should be given the benefit of the doubt. He can be acquitted. And if you have any more evidence and time, you can go and bring him back to court. But let's not allow them to be keeping them.
And also, this is only discharge. They can always come back.
Yeah, this is discharge. You can always, if you have time or you are less busy, you go for him and bring him. Yes. You know the clause there, unless. Yes. Say this or that. So usually they will not leave. Yes. This is what was there.
Yes.
We want innovation. The court is not deciding. This has been the practice, and the court will never decide in your favor. Hey. It is proposed that clause 208. Hey, sorry, AG, are you fine?
Yes,
They don't mind.
From the practical implementation point of view, there are risks. But as always, your decision overrides. But there are serious risks for consideration. We can be dealing with a very precarious situation here, but it's fine. We've got situations where people are discharged. In the next couple of hours, you cannot see them. They have gone. You see, we are talking from the... Anyway, we can proceed.
All right, let me put the question then. It is proposed that clause 208, non-appearance of prosecutor at hearing, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So there is nobody thinking otherwise.
Clause 209, appearance of both parties.
What do they mean by appearance of both parties?
Chair, if at the time appointed for the hearing of a case, A, both the prosecutor and the accused person appear before the court, which is to hear and determine the charge, or B, if the prosecutor appears himself or herself, or by his or her counsel, and the personal attendance of the accused person has been dispensed with under Section 100, the court shall proceed to hear the case. What is Section 100? Section 100. Power to dispense with personal attendance of accused. When a magistrate issues a summons in respect of an offense other than a felony, he or she may, if he or she sees reason to do so, and B, shall, when the offense with which the accused is charged is punishable only by a fine or only by a fine and imprisonment for a term not exceeding 3 months. Dispense with the personal attendance of the accused, provided that he or she pleads guilty in writing or appears by counsel.
Of both parties stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 210, objections to charge to be taken at once.
210. I think 210, what your proposal is to remove the S on the objections. You know, the heading is objections to charge to be taken at once. Objection to charge. Huh? You want the removal of S. Yes, you are now proposing that that S objection S be removed on the heading. Yes. Yeah, objection to charge to be taken at once. That's what they are proposing. Legal. It's okay. We remove it. Okay? Yes, Honorable Nominated Member.
Any clarification? Because if you say objections to charge to be taken at once, it implies that there is more than one objection. If not, why are you taking them at once? So now, if you take out the S from the objection, that is just a singular. And you are saying to be taken at once, implying that there is more than one objection. So, I'm not legally minded, but I seek some clarification on this.
Understanding is in drafting, singular takes care of the plural. Just like before, he takes care of she.
You specified
this is what I am told.
So this
it's usually best in drafting use the singular than the plural. The clause 210, objections to charge to be taken at once stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 211, adjournment.
You want to read? Adjournment 1. Before or during the hearing of a case, the court may A. adjourn the hearing to a certain time and place, to be then appointed and stated in the presence and hearing of the party or parties or their respective counsel, then present. B. allow the accused person to go at large. C. commit him or her to prison. Or D. release him or her upon his or her entering into a reconnaissance with or without sureties. Yes. So I think that's a normal thing they do. Yes.
It is proposed that clause 211, adjournment, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 212, non-appearance of parties after adjournment.
It is proposed that clause 212, non-appearance of parties after adjournment, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 213, accused to be called upon to plead.
It is proposed that clause 213, accused to be called upon to plead, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 214, procedure on plea of not guilty.
It is proposed that clause 214, procedure on plea of not guilty, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 215, right? Yeah. 215, acquittal or discharge of accused person when no case to answer.
No issue. It is proposed that clause 215, acquittal or discharge of accused person when no case to answer, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 216, the defense.
Yes? Is there somebody saying something? It is proposed that clause 216, the defense, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 217, opening and closing of case for the prosecution and defense.
It is proposed that clause 217, opening and closing of case for prosecution and defense, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 218, amendment of charges.
they are going to amend your charges. It is proposed that clause 218, amendment of charges, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 219, the decision.
The proposal.
After a court has hears, so we say after the court has heard, we want to put H-E-A-R-D instead of S.
It is proposed that clause 219, the decision, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 220, drawing up of conviction or order.
Me, I have 227.
Yeah, I can see.
Me, I don't have that. From 219, I went to 226.
Let's see. Turn, let me see. Turn the page. No. Here, you can use my extra one. I have an extra one here. I have an extra one.
You have an extra. Just want to see whether they pin the pot, whether they put it somewhere else.
No, they missed the page.
They missed it. Yeah. It is proposed that clause 220, drawing up of conviction or order, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 221, order of acquittal, bar to further proceedings.
It is proposed that clause 221, order of acquittal, bar to further hearings, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 2, limitations and exceptions relating to trials before subordinate courts. Clause 222, limitation of time for summary trials in certain cases.
It is proposed that clause 222, limitation of time for summary trials in certain cases, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 223, procedure in case of offense proving unsuitable for summary trial.
It is proposed that clause 223, procedure in case of offense proving unsuitable for summary trial, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. 224. We are now going to part 6.
Part 6. Commencement of criminal proceedings in the High Court. Clause 224. Commencement of criminal proceedings in the High Court.
You have no problems? No issue. It is proposed that clause 224, commencement of criminal proceedings in the High Court, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 225. Filing of information and summary of evidence.
Go ahead.
Chair, we are proposing that we create a new clause, subclause C, to create that will contain copies of all the documentary evidence to be relied on by the prosecution to serve on the defense.
Okay, what is the clause?
So here it is saying the Attorney General or a person authorized by him or her may commence criminal proceedings in the High Court by filing with the Register of the High Court an information which shall be in the form of an indictment and state in writing the charge against the accused.
Yeah, let him just learn.
Yes, I want to observe it there.
B, a summary of evidence which shall comprise a list of the witnesses whom the prosecution proposes to call at the trial and summary of the evidence to be given by each witness. So our proposal is for this documentary evidence to be given to the prosecution as well.
Pardon?
To be given to the prosecution.
What to be given to the prosecution?
We are saying the copies of all documentary evidence to be relied on by the prosecution be served on the defense, to be given to the defense.
But you need to ask AG for that one.
The defense should also have the copies.
You know,
if you put all the summary of evidence and you put it together and give it to as part of the charge sheet, you know it's already with the court. It should be served to the defense as well.
Huh? The prosecution. AG, are you following? Yes. What is your? They are saying we create another paragraph.
Yes. I saw you proposing that copies of all documentary evidence to be relied upon by the prosecution must be served on the defense. Yeah, to some extent, this is what is happening because this is the High Court. So to avoid surprises, it's a principle of disclosure. Yeah, we have no objection, but we are proposing to add something to that. We have a proposal because you came up with this. It's important that we also control the information that will be shared. So we are coming with we are proposing another clause if this is accepted.
It means we are going to have A, B, C, and D.
We are proposing C. The one that we are proposing probably
will be D.
We might want to make it 2, so this one will be 1. Between 225, we can create someone. Then what we are proposing is 225 something.
Okay, all right. May we hear your proposal now? C. What's your proposal?
Our proposal,
can you read it for me?
225, yes. Our proposal is that we create a subclause C.
Yeah, what is the subclause you are proposing?
Yes. That all documentary evidence to be relied on by the prosecution be served
all documentary evidence
on the defense, be served on the defense.
To be relied on
by the prosecution.
By the prosecution.
Must be served on the defense.
To be served or must be served?
Must be served on the defense. That one is for the drafter to determine.
Must be served
on the defense.
I think
society, copies copies of all documents. Copies basta.
And all documentary evidence. Yeah, that's why you add copies. Yes. Honorable, now may we hear? Yeah, no, let's hear yours first.
We're proposing now from the Attorney General on top.
Honorable members, please listen to the proposal.
Yeah, we are following.
If we have Attorney General at the top as one, then these three clauses now will be 1A, B, and C.
Yes.
Yes.
So we are proposing a new paragraph 2.
2, yes.
Yes, go ahead.
Which will read, where the documentary evidence to be served on the defense contains personal or sensitive data of witnesses or accused, the defense shall use the disclosed evidence solely for the purpose of the legal proceedings and shall take all necessary measures to protect the confidentiality and integrity of any personal data contained therein. And then we even have a third one, because we need to prohibit this by saying any unauthorized use, disclosure, or retention of personal data shall constitute a breach of this provision and may be subject to penalties under applicable data protection legislation. So we can share this with the team. Exactly. The principle that we are saying here, it sounds a bit long. What we are saying is, during investigation, investigators can come across a lot of data that are sensitive and personal in nature to either witnesses that are going to testify or sometimes even the accused himself. And now if the law is asking us to share it with the other side during trial, no problem, because trial at the High Court is based on the principle of disclosure. But the party receiving that data should be reminded that that data is only to be used for the purpose of that trial. And people's personal data that he is receiving must be protected. Yes, that's all that we are saying. We are not asking for more.
Can you read it for us?
No, but Speaker, that's long.
So we can share this.
Huh?
We can share it.
You can't write all that.
We've drafted it already. You want me to read it? You copy it with your hand?
I want you to copy it.
No.
All right, unless you. Yes, we need the copies.
Okay. Yes, exactly. They will share copy.
Huh? I can read it
Provide
again.
a copy.
But that all that we are asking, the principle of it, you understand, right?
Yes,
and,
no.
It's acceptable.
I'm fine with it.
Okay. Yeah.
Members, I think we are fine. It's just to protect the information from.
Good. Honorable Chair, what AG has talked about is very important. So now, and what of the person who has been served with that information, the consequences of giving that information to the third party? Yes, are we going to have that equally in the legislation?
If you go to misuse the information. Yeah, but I think he said something like, he read something like that.
So we are having 3 and 4. We are adding 2.
We have 2
and 3.
2 and 3.
So 3 say any unauthorized use, disclosure, or retention of personal data shall constitute a breach of this provision, yes, and may be subject to penalties under applicable data protection legislation.
Yes.
Just that.
It's fair, valid.
Yeah.
Anyway, yeah.
I don't understand the rationale.
Ma'am? Lower Salum. Yes?
You're not following.
Yes. Now, the committee is recommending on 255A that you delete the "and," of course, which is in line. Filling of information and summary of evidence. They recommend that you delete "and" because they have now added one more paragraph, making C. So now, I'll propose that we also put "and" after B.
After witness.
After witness.
So the full stop change.
Yes,
comma.
the comma. And
No,
no, that is
a
separate number. Separate number.
2 and 3.
Yes. So to connect B and C. Yes. Exactly. That's what I'm saying. Yes.
Yes? Is it Lower Salum?
Yes. What the text that the AG is reading, we don't have it, but then it's good also the AG to give it to a table office to print it out, whereby you can get a copy and also.
Yeah, I think that's why you are lost. We have agreed on that. That's what we were insisting on, that we don't have it. I wanted to write it down. But the table office will get it from him, they will make copies and then circulate it to us.
It's shared with us and we shared it in the group.
I'll be copying the Lamola. I'll tell you, I can copy the Mola. For Mulana Lebuko di Mola, man, I'll massy up.
I disagree with them because our rule of procedures doesn't allow us to use devices. So let them make it hard print and give it to us.
Let them give you hard print so that you will put it there. It will complete. Yes. Then we will make those copies and then probably by tomorrow we get the copies. But you have had the proposed amendments all together. Now I put the question. It is proposed. Yes, the Honorable Member for Lower Salum.
Yes, Honorable Speaker, there are instances whereby the evidence are tampered. What about if the evidence are tampered during the court proceedings? What will happen?
Separate issue. It may be covered somewhere. This one is filing of information and summary of evidence. This is what we are dealing with. It is proposed that clause 225, filing of information and summary of evidence, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 226, form and content of bill of indictment.
It is proposed that clause 226, form and content of bill of indictment, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 227, information and summary of evidence to be authenticated by the Attorney General.
Yes. Is the caption, 227, the caption, where you have by Attorney General. We just want an Article D there. THE, before Attorney. You've seen it.
Following. 227, the heading is by Attorney General. That's what is there. It should be by the Attorney General. It is proposed that clause 227, information, yes, Kian West.
Yes, Majority Leader, can he further explain why the Article D? What do you want to qualify?
It's the committee, it's not me. it is the committee that recommends that we have Article D, because if you look at the text, the Attorney General on the text. So, for
information and summary of evidence to be authenticated by the Attorney General.
Yeah, that's in line.
It is proposed that clause 227, information and summary of evidence to be authenticated by Attorney General, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Part 7. Procedure in trials before the High Court General. Clause 228. Remand pending trial in High Court.
We hear you.
I think this is a bit technical. It's saying we flag to ascertain if a replica of section 208A is anywhere in the bill. If not, is to replicate here in this section. So, and yes, and 208A is saying, for example, 1, if in a trial before a subordinate court, A, the accused person comes before the court on a summons, warrant or otherwise. So if it is not anywhere in the bill, it's saying it should come under this section 228. So I really, it's saying we flag if a replica of section 2 in this bill.
In this bill?
Yes. If it is in another place, fine. But if it is not anywhere in the bill, it is saying we are recommending that it comes under this section.
In fact, it is
so I don't know.
It is an identical replica. It is an identical replica.
Identical replica.
Word for word. Yeah. In fact, for me, I thought you guys were.
You are still using legal language.
Yes. Okay, it's a replica.
I forgot how this thing comes.
No, it's. I think the suggestion was to remove it. No.
No, to bring it under section.
It's not. It's not here. It's not here.
It's the same. It's the same thing.
Huh? Where? It's the same thing with what?
With 208.
Trial at the magistrate court is summary trial. Let's not please bring the same thing at the High Court. Please, it's completely different, yes. I beg. Okay.
It's. I don't understand. What is your point? What are you raising? What did you raise?
He's saying 208 of the criminal offences bill.
208A.
Huh?
That's what he's saying. Yes.
208A.
208A.
Yes, 208A.
It should be the same as 228 if it's not already there.
No, he's not saying that it should be the same. He said it should be brought down here.
Yes.
Yeah, it should come into here. It should come in here.
Same. The text is the same.
But this one is not saying that.
No. So it's saying what is
here? 228. It is not saying that. They are different.
Can you read your 208?
He just read it.
What is it? Read it.
208 is saying if in a trial before a subordinate court, the accused person comes before the court on a summons, warrant or otherwise.
No, you have the wrong section. You're not quoting 208A of.
Yes, that's what I'm.
Of the bill or of the court?
Of the bill.
Of this bill.
Of the bill.
I'm reading the bill.
No, is it of the, because he's thinking that you are talking about the
offenses.
Act.
Yes.
Okay.
208. Okay.
Be careful. Yeah, it could be. Be careful. Just look at your consideration properly. Just take your time.
He's saying no. Just a minute. Just a minute.
He's right. He's saying the black proceed. Whether if the to ascertain if 2088 is replicated in this bill, and if it is 208 of the old bill is replicated in this bill, if not, we should put it in this section.
Yeah, there's 208 of the offenses bill.
No, of the
If it is not in anywhere.
Of the
code, not the bill.
Of the code, yes.
Chairman,
There's no 208A.
Chairman,
Is there?
which bill? Chairman, look, what we are saying, what are you talking about? Chairman, offenses. Chairman. Exactly. Then you are getting some, you people, put your axes together.
I'm saying the writing is not clear, but what he is saying was let's check the code.
He's saying they are the same, he has checked it. Yes. It's the same as the text here in 228.
Is that what you are saying?
You don't believe what I said. Confirm to him that's what you said.
Our suggestion is let's ascertain from the code. If it is the same as this, then that's fine. No, why did you say
Put it to AG.
You know, if it is not there, you replicate it here. What he is now telling you, he has gone back to look at it. What is there is the same as what is here, word to word. But you people should have done that. You should have done that before you made the addition.
Yeah, okay, I agree.
Egi, are you following us?
It's clear now.
We are 228. It is proposed that clause 228 remand pending trial in. Yes, please.
Yes, this clause has made a reference to clause 124, sorry, section 124. Yes, it has made reference to section 124 with respect to the issue it has talked about here. That is a case or offense that is not triable under a magistrate, may wait for a given time to be summoned by the High Court. So, but that time is vague here. But I try to look at clause 124, and I have not seen anything like that. If I can be enlightened about that, so that this will not be an open-ended something that it is seated there, it is not summoned before the High Court, the person is also seated there, cannot be tried by the magistrate. Yes, and this section made a clause, a reference.
All right, let's read. Can you help us read this section? Yes, please read it.
Where a charge has been brought against any person of an offense not triable by a subordinate court, the magistrate may, subject to section 124, remand that person into custody until such time that the matter is mentioned in the High Court.
Right. Yeah, this is about bail issues. If I think what I understand is you are the magistrate court, and probably the jurisdiction should be different. It's mentioned there. The magistrate may determine to put you in under custody or refuse to bail until it is heard at the High Court or other courts. I think that's what they are saying. That's the normal process.
Well, yes, but not quite. It's
Chair.
The High Court is fair. It's not as many as magistrates. You brought somebody, you brought him to a magistrate court, and it's not his domain. Probably this is murder or something else.
why bring him to
Because the other court is not available, and the person cannot be kept more than 24 hours, 48 hours, or 72 hours. So you have to bring him to a magistrate court to beat that system so that he is not released to go.
It's good that you said.
Yes. You cannot do the court. You know it's a serious one. Yes, please.
Yes, but that process cannot be excessive, and it has to be controlled as well, because you cannot just open it to leave it at the mercy of the magistrate to say how long you're going to stay before you are summoned before the High Court.
But most of the laws you have together is at the mercy of the judge.
But what I mean here, you are not treated before the court. Here is to keep you at the custody, being remanded until you are summoned before the High Court. This is about that. So that cannot be an open-ended.
No, but what are you suggesting? What are you suggesting? Yes. Let's hear some clarity so that we will be.
What you need to understand here is once the case is filed at the court, the executive is no longer in control of the case. It's a judicial process now. If the magistrate declines jurisdiction and remands you, immediately under their judicial process, without interference of the executive, the case file is sent to the High Court, to the Chief Justice. And as soon as the Chief Justice receives the case file, he assigns it to the judge. And immediately the judge receives it, the state is notified and given a date to appear and file charges, and you're given a period of time. If you don't file charges, you to be acquitted. That the state doesn't have a discretion to leave you to languish there, because the judiciary is already seized with the matter. That's how it works. It is the magistrate that sends the file to their boss in Banjul, to the Chief Justice, and immediately the case is assigned to a judge. Once a judge receives it, because it's a judicial process, the judge now will send a hearing notice to the state law office. They don't have to wait for the state to decide when they will come.
Honorable Minister,
it doesn't work that way.
Honorable, what you are saying is, it's no more in the hands of the executive. If there is delayance, is the judges and magistrates who are, yes, and they are the custodians of all these things. If it is expedited, that's what he is saying. That's what he is saying. Yes. I'm coming, one of you.
Yes, the question is why do they take this person to a magistrate court instead of taking the person to the High Court, which is the appropriate court? Why are they doing that? There is a reason why they are doing that. Yes. In all regions, you have High Court. But I'm saying you have High Court everywhere. In every region, you have a High Court. That's everywhere again. You have a. No, it's not the problem. They should take the person to the proper court. No, you have a police headquarters in every region, so the High Court is also in every region. So there is no justification to take an accused person. It does.
So this is practical problems now of law enforcement. Our Honorable Speaker partly answered it. The magistrate courts are more accessible than the High Court to the police. Remember, investigations start with the police. The police don't use the High Court, they only use the magistrate court. And remember, they have detention power is only 72 hours. They can have a very dangerous criminal in their hands. Within 72 hours, they may have to release the person. And the only charge they may charge that person may be a charge that the magistrate doesn't have jurisdiction to prosecute, to hear. But at least the magistrate can deal with the detention matter and then refer the file.
It's a procedural matter. Him to the magistrate, and the magistrate feels with all that there is no need for you to keep the man, he can grant him bail and go.
Even if we have the high courts, the police have to complete the investigation, refer the file to AG's chambers for opinion before we can approach the high court. They cannot do complete an investigation, do all that within 72 hours.
Thank you, Chair. Chair, I think we have to look at, this remand pending trial in the High Court. The last time we went around all these prisons in the Gambia. We've seen people on remand for more than 7 years. So if you look at this part, been waiting for trials, and then as the minister is saying that when it comes out of their hand, they have no say in it. What can we do to avoid those kind of issues?
Okay, let me clarify before my statement is misconstrued. What I am trying to say is, yes, there are people in remand that have stayed there for longer than normal. But those that are in remand are in different categories. This particular remanding we're talking about, this is the one that I said, once we file the case in the court, in the subordinate court, the judicial process have kick-started. The detention now becomes a judicial detention. Now the judiciary, the normal practice is that the magistrate now sends the file immediately to the Chief Justice's office. And the Chief Justice assigns that file to a judge. Once a judge receives the file, a hearing notice is sent to the state as soon as possible. And they do not leave it at the discretion of the state. That's the fear I am allaying. Some people believe that once the magistrate remand the individual, now is at the leisure of the state. The state can take months or any time they want before they file the charge. That's what I'm trying to say. No, it doesn't work that way. Because judiciary, the magistrate, as soon as he reminds somebody, the magistrate immediately transfers the file to the Chief Justice. Assigned to a judge, the judge issues a hearing notice. And the judge will tell the state, we give you this much time. If your charges are not here, we will discharge. That's how it works. Now, the other people that are in remand, those ones they are already charged, trial is going on. Either they were refused bail or they were granted bail, they couldn't fulfill their bail. But that's a different thing from what we are looking at this stage. So it's important we do these distinctions clearly.
Very important. Noted.
Is that the police would arrest people knowing that they don't have a case with them. They would rather, instead of taking them to the right place, they will just take them to the magistrate court so that the magistrate can detain them, even though they know that they have not done their job properly, and they will be keeping you at the mercy of the magistrate. The magistrate court will decide, because they know that within 3 days they have not done their work. So you will be there until after some time, then you are released. And during that period, you will suffer. So that's
blame the magistrate first, because the police don't have the right to force a magistrate to refuse to bail. The magistrate has taken an oath to do justice. When anything comes to him or her, what needs to be done, he does it. But what we are saying is the police cannot easily access the High Court. When the police, when they hold, for instance, you get somebody, a criminal or a murderer, you get him. It cannot be tried in a magistrate court. It has to go to a High Court. And the police cannot go directly to the High Court.
as they can go to the magistrate court to seek for something. So what they are saying now is the process itself. When you go there and, for instance, you are remanded, the process, the delayance of the process cannot be, the executive cannot do anything about that. It is always time-based. This is what he is saying. Now, if, for instance, you are reminded that you do your submissions within a period of time and you have not done it, they can they can release the man to go home. But the problem is the person that has committed that crime is an accused, though, but he has to be restrained somehow because he could escape and go. Yes, let's hear you. Yes, Honorable Kiam, member for Kiam.
Yes, Honorable Chair, there has to be a defined process to do that, because we cannot pretend in the law, taking people under the jurisdiction that we know they cannot be tried under. That's what we're doing. We are doing pretense here along the line. And legislation, we should not do that. We are taking people, criminals, under jurisdiction where we actually know they cannot be tried under, just to delay the process. I don't know.
Honorable, that is not it. I don't think you listen. You have a concept that you're holding onto, and you are not opening up to listen to what people are saying. Because that's not the purpose. What you are saying is not what he said. No, is it what we said? What was said here is, one, pardon? Are you saying something? Yeah, one, what he said here is, for instance, in a murder case, you know, the magistrates don't deal with murder case. But here you have a murderer. You accuse person who is accused of murdering somebody. The police have a right of detention to not more than 72 hours. So what they are saying is, if within that 72 hours they cannot access a judge or a high court judge or a magistrate to do it, it means it's now obligatory for them to release that person. This is what they are saying. Now it's easier to access the police. It's easier for them to access a magistrate.
So the reason why they are taking the person to the magistrate court is to seek for detention of the person.
That's their wish. No, just like honorable. In fact, honorable. Why do they take you to court? It's for you. They believe that you have committed and you are guilty. That's why they take you. Now it's the court that tells you, oh, you brought this man for this crime, he is found not guilty.
Sometimes they take you to court and say, we have not finished.
Yes, but the court, even if you have not finished, the court will make a determination where that case that you have not finished, whether it warrants that this person be detained. The court makes that determination. It's not the police who makes that determination.
Members, I understand your constraint, but when you look at section 19, personal liberty, of the Constitution, it says a person who is arrested or detained, it has A or B, but then it went further to say, in B, upon reasonable suspicion of his or her having committed or being about to commit a criminal offense under the laws of the Gambia, who is not released, shall be brought without undue delay before a court in any event within 72 hours. Now, the 72 hours marks the end of police detention powers. But you will all agree with me that there are certain people, you cannot release them. So you need a judicial order to continue to keep them. Now, the nearest available judicial officer near that the police can access is a magistrate court, irrespective of whether that magistrate have jurisdiction over the crime itself or not. They have to go to court, but they have to convince the magistrate that there is a need to continue to keep this guy. If the magistrate is not convinced, he will grant bail. If the magistrate is convinced, sometimes it's for our own security. We have to look at this thing carefully. In as much as we want to give as much individual rights as possible, our own personal securities are also concerned.
If we remove this clause, most of our big criminals will go. I'm telling you.
Yeah, now I'm saying is that made it clear. Our doubts are not clear because of that.
And because even if you see it, yes, and even there is because of the 72 hours that may if you cannot do that, you must release the person. You release him, he's gone into Casamas and he's gone. That's why the magistrate listens to them. There are times when the police come with somebody for detention, the police would refuse, the magistrate would refuse. Because the reasons adduced are not sufficient enough. So he would release him or bail him for a bond. But if he also believes that this thing is not this, then he will detain him as even the High Court would have done. This is what is happening. It's clear. Okay. All right. Thank you very much. Where are we, sir?
We're at 228.
228.
Yes. So we're leaving it like that.
Yes. It is proposed that clause 228 remand pending trial in High Court stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Subpart 1, arraignment. 229, pleading to information.
It is proposed that clause 229, pleading to information, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 230, objections to information to be taken at once.
It is proposed that clause 230, objections to information to be taken at once, be part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 231, orders for amendment of information, separate trial, and postponement of trial.
No problems? Pardon? It is proposed that clause 231, orders for amendment of information, separate trial, and postponement of trial stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 232, quashing and information.
It is proposed that clause 232, quashing and information stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 233, procedure where accused is charged in information with previous conviction.
It is proposed that clause 233, procedure where accused is charged in information with previous conviction stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 234, plea of not guilty.
Yes, please.
An accused person who pleads not guilty shall be deemed to have put himself or herself to trial. What does that mean? Yes. No. If I said I'm not guilty, why should I go for trial?
You have asked the prosecution.
Now, I accuse you of something. I take you to trial. You pleaded not guilty to yes, and you plead that you are not guilty. You are telling the court that let me prove that you are guilty.
Can I speak?
taken to court, you take a plea, and you either say guilty or not guilty. If you are guilty, it goes direct to judgment. If you say you plead not guilty, it means you are now asking that let them go through the process of trial for the prosecution to prove that what he alleged against you is true.
Okay, I don't know whether it's the language of the court. What I'm saying is, whether it's the language of the court, but I think this sentence needs to be really looked at. So if I said I'm not guilty, that opens trial to go. But I'm not demanding the trial to go. It's the court now.
It's not saying you.
No, this is what he's saying.
No, it's not saying you are the one who is determining. He's saying it is assumed.
Where are the Kiankas?
You understand?
Look at the Badibunka. Huh?
It is deemed. No, it's deemed. It shall be deemed to have put himself or herself.
It is proposed that clause 234, plea of not guilty, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. But where are the Kiankas?
There's one up there.
I think they are hungry.
Clause 235, plea of autrefois acquit and autrefois convict.
They have come again.
Sorry?
Yes, that's where we are. No, we are at 235. He was on 234. Fasting is taking its toll now. Huh? It is proposed that clause 235, plea of autrefois acquit and autrefois convict stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. This is their own jargon. This is how they used to.
It's French.
But it's for your use, not for us. We don't use this.
He wants to know the meaning.
Now, yes, but it's for you people.
Yes. No, but it's not for us. It's for the accused person to use. But I understand what you're saying.
No, when I say you, who takes the accused? Who prosecutes him? It's not you people. Who is the judge? It's not you people.
It's basically double jeopardy. Double jeopardy. The principle.
Yes, clause. This next one.
Clause 236, refusal to plead.
Refusal to plead. What are they saying about that?
I'm sure it will be not guilty.
Yes, but there could be issue for some of us. Refusal to plead. What is he saying?
Not guilty.
If an accused person who is arguing on any information refuses to plead, or by reason of infirmity cannot answer directly to the information, the court shall, A, if it thinks fit, order the registrar of the High Court or other officer of the court to enter a plea of not guilty on behalf of the accused person, and the plea so entered shall have the same force and effect as if the accused person had actually pleaded the same. And B, thereupon proceed to try whether the accused person is of sound or unsound mind. Well, this should be C, right? Or B1. If he or she is found of sound mind, proceed with the trial. And 2, if he or she is found of unsound mind and incapable of making his or her defense, proceed in the manner provided by section 178.
Yeah, I think this one is clear.
Yes, it's clear.
It is proposed that clause 236, refusal to plead, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 237, plea of guilty to charge.
It is proposed that clause 237, plea of guilty to charge, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 238, proceedings after plea of not guilty.
It is proposed that clause 238. Yes, please.
This section has also made another reference to section 234. 234 okay.
It is proposed that clause 238, proceedings after pre...
I think he might have a point. I think he might have a point. The cross, the referencing should be 3236, if I'm not wrong.
Honorable, can you read the 238 for us? Read
238, proceedings after plea of not guilty. If the accused person pleads not guilty, or if a plea of not guilty is entered in accordance with the provisions of section 234, the court shall proceed and try the case mentioned. That should be? It should be 2-3.
Refusal to plead.
Instead of 2-3-4, it should be 2-3-6. Refusal to plead. If the accused person pleads, this is pleads not guilty.
34 is not guilty.
Yes.
Guilty is entered on his behalf. That's in 236. Yes.
No, I don't think. If an accused person who is
Honorable,
refuses to plead, or by reason of infirmity cannot.
234, an accused person who pleads not guilty shall be deemed to have put himself on trial. That's what 234 said. This has nothing to do with that. This one is saying, if an accused person pleads not guilty, or any other, or if a plea of not guilty is entered in accordance with the provisions of 234, that is only on provisions of 236, not 234. Yes.
236.
236, look at it. Yeah, but we just concluded that. We read it through. He said, let's read 236. If an accused person who is arraigned on any information refuses to plead, or by reason of infirmity cannot answer directly to the information, the court shall A, if it thinks fit, order the registrar of the High Court or other officer of the court to enter a plea of not guilty. This is what he is making reference to. If that person who has not made it himself, but the registrar entered into a plea for him, is equally part of it. And he says, on behalf of the accused person, and the plea so entered shall have the same force and effect as if the accused person had actually pleaded the same himself. You are sick or you cannot move or something cannot happen. You are asked to make a plea. And then that is what this one is making reference to. It's 236. Yes, where's my pen? I'm coming. Yes? But do we get this clear? 238.
Is proceedings after plea of not guilty. Whereas the caption for 236 is refusal to plead or not able to plead.
Yeah, but the two are captured. That's not. We are not dealing with the heading.
So which one?
We are dealing with the intent, with the content of 238.
Yes.
Not the heading. But listen here, Swar, let's listen here. Or if plea of not guilty, is entered in accordance with the provisions of not guilty. We are wasting time, honestly. This is simple language. I tell you, you are not in agreement. You don't want to take responsibility when it is wrong. So why we will never accept. It is proposed that clause 238, proceedings after plea of not guilty, stand part of the bill as amended. Those in favor, please say aye. Those not in favor, please say no. The ayes have it.
Clause 239, power to postpone or adjourn proceeding.
It is proposed that clause 239, power to postpone or adjourn proceedings, stand part of the bill. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Honorable members, is 1356. We are at part 2. I think we will stop here. Conveniently, we go for prayers. But my problem actually is, when we say a time factor, members will not come in. I'm telling you, yesterday it happened. When I came in, there were only 4 people inside. And most of the senior NAMs don't come in on time. So we will suspend the committee of the whole house. The house will now resume. Honorable members, the House now resumes. You know, if you look at faces, you can deduce a lot of things. People's faces. You can deduce a lot of things. You know, we are in Ramadan. At John. No, you know, I looked at your face. That's why I made this comment. Honorable members, we can now go for 30 minutes. Am I right? It's almost 2 minutes to 2. We can say 14:30. 30 minutes. But please, honorable members, by 14:25, let's be in the hall. Please. The House is now adjourned until 14:30 hours prompt.